Hi, my name is Marck Joseph and I'm a South Florida family law attorney. And here are the huge changes to Florida family law as of 2023. All right, so as of July 1st of 2023, there has been a host of new laws that have come out that seriously affect family law as we know it in Florida. From alimony, father's rights, time sharing, modification, domestic violence injunctions, even child support. So much after July 1st has changed in family law, we have to talk about it. So the way that we're going to do this, I'm going to give a general overview as to what's changed, and then we're going to go ahead and have subsequent videos that talk about some of these changes in more detail. But before we get into it, like, subscribe, and hit the notification bell so you can be updated when we introduce these newer videos. All right, so the first huge change in family we're going to talk about is in relation to alimony laws. Now, this is a huge deal because Florida no longer has permanent alimony, with some exceptions. This isn't all. Now, in the state of Florida, the court must consider the adultery of the spouse in its alimony calculation consideration if there's evidence that it exists. The alimony factors overall have changed. In some cases, it's been tweaked a little bit, and in other cases, some of the factors are removed. There's been changes to the definitions of what's considered a short, moderate, and long-term marriage, and its effect on alimony awards related to durational alimony. There is also now a determination of what the maximum alimony award you can receive if it's durational, based on the length of the marriage, as well as an extension to what rehabilitative alimony is in the length of time. So we're going to hit the biggest part, the fact that there is no more permanent alimony. Now, what the court does allow is durational alimony, which always existed, but now it's tweaked to take in consideration the range that will be awarded. The simplest way I can break it down is like this. Florida no longer has permanent alimony. Florida uses durational alimony and the length of time a couple has been married to determine the length of time that they're going to receive alimony. Now, there are exceptions to this if you want to extend the durational alimony period. I'm going to touch on them briefly here. However, the future video will go into much more detail to understand if this applies and can affect your case. So the factors that are taken into consideration if the court may extend the support, and I'm going to just quote the statute as written because this is new. So there's not really case law or some intense examples as to how this is going to play out in court. So the factors that the courts can consider to extend an award of durational alimony is 1, the effect that the person's age and employability has in limiting their ability to become self-sufficient. 2, the extent in which a person's financial resources affects their ability to be self-sufficient. 3, any mental or physical condition that could affect their ability to become self-sufficient. Or 4, any condition of a dependent child, minor or adult, and the need to care for that child, which affects their ability to be self-sufficient. Now, it should be important to note that the 4th factor of considering the dependency of a minor adult child that's common to the marriage is the fact that if that is the factor that's considered, the support in theory would be extended to the period in which that child or adult person becomes and maintains that dependency. All right, So the summary of the alimony changes include the fact that there's no more permanent support. Durational support is the main version of alimony, which takes in consideration the length of the marriage. The definitions for the length of the marriage has changed, where short, moderate, and long term has new periods of time to be considered by the court. The statute also changes the maximum amount of support that can be awarded in most circumstances. It also changes the alimony factors that is considered by the court, as well as now making it mandatory that if there's evidence of adultery, it needs to be considered and its economic impact on the marriage or the equitable distribution. The new statute also extends out rehabilitative alimony to 5 years. And overall, the new public policy of alimony is to essentially assist a party that would need alimony into achieving self-sufficiency or self-support. So now on to the maximum amount of support that can be paid. So now the statute reads that the amount of support that can be paid is either up to the person's need or 35% of the difference of the party's net income, whichever is less. The simplest way I can break down what that 35% calculation looks like is this. If one person makes $10,000 a month net and the other person makes $4,000 a month net, the difference of their net incomes is $6,000. The maximum amount of support that can be awarded in that case is 35% of $6,000. So in that case, the maximum amount that could be awarded is $2,100. Now keep in mind, if their need is less than $2,100, let's say it's $1,500, then according to the new statute, it would have to be $1,500 because it's less their need or the amount difference between the parties' net income. There is also no durational alimony for a marriage lasting less than 3 years. Now, the court must consider a supportive relationship in modifying alimony awards and are required to reduce or terminate an alimony award if it finds that a supportive relationship exists. Now with that, the statute has a new definition of what a supportive relationship is and has now tweaked the factors as to what the courts need to consider when determining what is a supportive relationship. These facts and evidence can go back as far as 365 days to make this determination. And what it is now is a burden shift. So the person who's paying alimony would have the burden to show that a supportive relationship exists. If they are successful in showing that, now the burden shifts to the person who's receiving the alimony to explain or justify why there should be a reduction or termination in their alimony award. Another change that's occurred in the alimony statute in relation to modification is that the payors of alimony can now request a reduction or termination of alimony based on their retirement, starting from 6 months from when their scheduled retirement is. While a lot of case law tend to support this proposition, it was never into the statute until now. There's actually more changes to the alimony statute, but we're going to touch on that when we discuss modifications. Now, these may be just as huge as alimony. To start, under Florida law, now, for fathers who have children with unwed mothers who sign acknowledgments of paternity, they officially have equal rights and standings similar to a married father and mother. This is something that you may recall in my previous videos when we would discuss paternity actions and the fact that it didn't matter if you signed a birth certificate, you did not have your rights established as a father if the parties were unwed. This now changes. Usually, when you sign a birth certificate, you need to sign an acknowledgement of paternity. This document, being properly signed, will allow you to have the same status as a married couple. This completely eliminates the theory that unwed mothers have ultimate guardianship of the child when the father signs the birth certificate. So for those who have not went to court to establish their paternal rights, however, they've signed the birth certificate, you do have the appropriate presumption of paternity. And there's more. Now in the state of Florida, there is a presumption that's rebuttable that equal time sharing is in the best interest of the minor child or children. Previously, the way cases worked, it was just a public policy that both parties have as much time sharing as possible. Now, the language in the statute is explicit that it presumes that 50-50 is best. So the person who doesn't want to have 50-50 has the burden to show that it is not in the best interest of the child or children that 50-50 time sharing be awarded to the parents. So to summarize these changes, unwed fathers who sign birth certificates have similar rights as married fathers, now under the statute. And the court, when addressing time sharing in a paternity action or even a divorce action, starts with 50-50 equal time sharing. And the parent who doesn't want the 50-50 equal time sharing has the burden of proving that it is not in the best interest of the child or children that 50-50 time sharing be awarded. All right, going into the next changes is the changes to domestic violence injunctions. Now, there is a new factor that can be considered for purposes of domestic violence injunctions directly in civil court, as well as the domestic violence factors in family court. And the essential summary is, now the courts can take into consideration the reasonable cause and belief that a victim or potential victim has for themselves or the child or children in being imminently affected by a domestic violence occurrence. So essentially, the belief or the facts that give them reasonable belief that a domestic violence situation can occur to them or the child or children can be a basis to address or receive a domestic violence injunction in family cases. Because this portion is so nuanced, I think it's going to be important when I go into this detailed video that this be watched, because this can affect a lot of circumstances and factors in Florida's families. Another factor that's non-domestic violence actions is if the partner or person who's being accused of the domestic violence had engaged in a pattern of behavior, actions, or anything that can be considered controlling, intimidating, no matter the period of time. So it doesn't matter if it happened a year ago or 10 years ago. If there's a set of actions that can essentially create some sort of intimidation or demonstrate control or anything like that, this is a factor that can be considered in domestic violence actions. Now we're going to go into modifications. This is something else that has gotten a serious overhaul in family law cases. I'm going to start with the parenting aspect of modifications. In the past, to modify a parenting plan, you would need to show substantial, material, and unanticipated change in circumstances since the entry of the final judgment. But now, unanticipated is no longer a factor to consider for modifications. In the past, the unanticipated factor created a lot of case on a lot of facts in which a lot of families were unable to modify their parenting plan because of their failure to show that the changes that they're requesting is unanticipated, despite it being substantial material. That is no longer a block. However, you still have to show that it's in the best interest of the minor child or children that these modifications occur. Now, this change may not affect most typical families. However, it does affect families who have a long-distance parenting plan. If two parents who stay 50 miles away from each other have the substantial and material change, that includes one of those parents moving within 50 miles of that other parent, the courts may now consider that enough of a change, coupled with best interest, to modify the parenting plan. All right, so the final main change that I'm going to discuss here today is the changes to child support, and more specifically, the changes to adult-dependent child support. This is important because now it is officially codified and there's an official cause of action for persons that are dependent past the age of 18, their parents or their guardian, to officially file a petition to request their support continue on past their minority. This in and of itself is very complicated in its nuance, but to just understand, aside from the typical previous law that you would have to request within the family court before the child turns 18, that there be adult dependent support established, this allows for a separate cause of action that can be instituted from when the child or children are 17 and a half years old to the future to request this relief. So, those are some of the major changes in Florida family law as of July 1st of 2023. As I've mentioned, these changes are a lot, and I'm going to need to go into individual videos to talk about them in more detail. However, this is one of those times where I do not suggest persons unfamiliar with family law go about this without the consult at minimum of an attorney. That being said, if you or someone you know is having a family law matter, especially any facts or circumstances that may be affected by these new statutes, give me a call, set a consultation. We can discuss your case as a whole, or we can discuss a bit more detail some of these changes and how it affects your case or their case. And again, like, subscribe, hit the notification bell. We do videos all the time on various issues of family law, but I'm making a special notice to everyone that I will be going into these videos in more detail and relates to these changes. It is important that anybody and everybody that is affected by these changes know and understand them. My name is Marck Joseph. Thank you for watching.